It's 11 o'clock and we can start our next session, which is our session. Now it will be 9th session on SEBI LODR Masterclass. It was superbly successful. Welcome by everyone. And this is our weekly Saturday knowledge sharing webinar by Mehta Mehta. Today's topic is webinar on the masterclass on SEBI LODR Scheme of Arrangement, Sale and Disposal of Undertaking Regulation 37A. And our panelist is, the presentation is done by Ms. Nayan Handa, partner of Mehta Mehta, handling our Delhi office. Thanks, Nayan. Welcome. Our panelist is, today's panelist is, as usual, our Mr. Bala is there, Mr. Sudhakar, our own Sudhakar Saraswatula is there, who doesn't require any introduction, and Mr. Suhas Kannoth, Assistant Company Secretary of Happiest Mind Technologies Limited. To formally introduce, welcome Mr. Suhas. Thanks for your time.
The pleasure is mine.
Yeah. To formally introduce Mr. Suhas Kannoth, he is a qualified company secretary and law graduate who holds 6 master degrees, my goodness, postgraduate diploma in then so many degrees, PG, DRL, NL, MBL, MBA, MCOM. I think it's too much. So I will say he is holding various degrees. He is currently working as an assistant company secretary with Happiest Mind Technologies Limited since December 2018. Handled IPO raising 702 crores during COVID pandemic. It was the first company to hit the market during the pandemic, and issue was oversubscribed by 151 times. Great. He has led the listing of NCD issuance for 125 crores, both on e-bidding platform and non-EBP platform. He led the award application process, resulting in winning Golden Peacock Award of Excellence in Corporate Governance 2020 by IOD, and the Best Governed Company in Listed Segment Medium category at ICSI National Awards for Excellence in Corporate Governance for the financial year 22. In financial year 22, both the awards were won in the same year. Great. Mr. Suhas led the team on the award-winning annual reports for the 3rd year by the League of American Communication Professionals. Great. He has worked as a senior analyst with Australia and New Zealand Banking Corporation for over 4 years. Great, something very different. Our welcome, Mr. Suhas, for your time. Thanks for that. We'll ensure that this kind of different varied education, qualification, experience, exposure will helpful. Really feel good to have a CS professional colleague who is entered into various fields. You have done in environment also, which is something very great, governance, because it says that your degrees, post-graduation diploma in environmental laws, intellectual property rights, business laws from National School of Indian University, MBA in international business, MCOM, and PG diploma in business and corporate law. Very varied knowledge and experience. Welcome to Mehta Mehta. Thanks for your time.
Thank you.
Our other panelists, of course, myself, Mr. Bala. We know Mr. Bala, who is having veteran in this profession, has various experience, and he is known for his knowledge and write-up on various decided cases. I think in our profession is known for his write articles regularly on decided cases. He was working with Foseco Limited and regular speaker. Other panelist is our Sudhakar Saraswatula. He is a chief consultant with Mehta Mehta, and as he knows, As everyone knows, he is a CA and CS both, and also member of Chartered Secretary and Administrator of UK. He has also worked as Vice President, Corporate Secretarial Department for Reliance Industries Limited. We thank all our panelists for the webinars joining us on our knowledge sharing session on behalf of entire team of Mehta Mehta. I'll request Mr. Suhas to share some talk something on the topic, and then Sudhakar, and then Bala, and then Nayan, you can start. Over to Mr. Suhas. Thank you.
Thank you, Dipti ma'am. Very happy morning to all the attendees. It's an absolute honor and privilege to be part of the famous master class series of Mehta and Mehta. I must say it's a noble initiative taken to help professionals like us across the country, if not the globe. Said that, what do you call it? I've seen all the previous panelists who have been on this series. Never in the wildest of dreams did I ever think I would make it to it. Thanks to Sudhakar sir, I had an opportunity to meet him at the SIRC regional conference, which was held in Bengaluru exactly 2 weeks back. That was last Saturday. And I convey my sincere gratitude to sir and the entire team of Mehta and Mehta for having me here. Getting to the topic for the day, the scheme of arrangements and sale and disposal of undertaking by under the SEBI regulations. I opt not to jump the gun and say anything on the procedures or regulations because we have a very comprehensive and enriching presentation waiting in the stores. Said that, I would the approach of my approach towards today's session would be to see it from a in-house company secretary's point of view, because whenever any company takes up any assignments like this scheme of arrangements, there will be a learned professional firm like the Mehta and Mehta or any other similar firms who's holding their hands. So the procedure, regulation, something which they'll take care of because they do it day in and day out. So my view would be from an in-house company secretary's point of view and provide some inputs from that angle. Thank you and happy learning.
Thank you, Mr. Suhas. Yes, Sudhakar.
Good morning, everyone, and welcome to our weekly webinars. And today we have reached the 9th webinar. That means already 2 months we have crossed after starting this masterclass on listing regulations. But before taking my topic, and let me also say a few words about today's panelist, Mr. Suhas. As Suhas has mentioned, last week I met him in one of the corporate secretaries conference at Bangalore. So when I saw him on the dais and the way he was expressing the amount of confidence and conviction what he has within him, I saw the spark that he is going to turn into a good professional. That why can't we have the privilege of inviting him on our webinars? In fact, today, till the time Dipti has read his biodata, I was not even knowing about anything about him. But the only thing what I know is that in our language, there is a saying that if you want to know whether the rice is cooked or not, you don't need to see all the granules, but just pick up the top one and you will come to know about that. That is with the experience, the homemakers or housewives, they do it. Similarly, I have also always used to say that I can pick up the people who got the spark in them. Suhas has proved me right today. When I was going through his biodata, I mean the resume, I say that still my competency as far as picking up the good professionals is still intact. So thanks very much, Suhas, for accepting our invite.
Thank you, sir.
Now coming to our topic, today's that scheme of arrangement, Regulation 37 and 37A. The mergers, demergers, amalgamations, spin-offs, all these are nothing but part of corporate restructuring. In fact, if you work in bigger organizations and especially conglomerates like Reliance, you will see that the number of mergers, demergers, what it takes every year, at least not less than 6 to 7, it happens. Quite a number of times, my trainees used to ask me in Reliance that why we go on incorporating companies and go on merging the companies. Sometimes they get confused also. Why on one side we are merging, and on the other side we are amalgamating, and on the other side we are again incorporating the companies. See, merger, demergers, the word, the corporate restructuring is there. That itself means that there are a lot of reasons for that. Say, for example, there may be a strategy. It may be a business strategy to incorporate a company and to merge or amalgamate or wind up a company. So, for example, in my previous company, when I was working, Berger Paints India Limited, it is a paint manufacturing company. And it is all that household paints it used to manufacture. At the same point of time, within the group, we used to have one more company in the name of Rajdoot Paints Limited. That also was catering the same thing. The only thing is that the markets were different. At one point of time, the promoter thought that why can't we bring the second company also to the public? Several analysts put the question that why already one paint company is there, which is a listed company, and you are bringing another paint company, which is also again going to be a listed company. Because if you want to have the brand image of a company or even for a product, it was felt that listing of the company is essential. So it got listed. After 4 years down the line, these companies again got merged. Rajdoot Paints, being the smaller company, got merged into the bigger company. Why again it was? The reason being to get the synergical benefits. When you are having two separate entities, then what will happen is the same kind of cost. Say, for example, advertisement. You have to have the advertisement for both the products. Everything you have to have is separate. So when you are having that, the cost benefits are not going to be there. And similarly, being a smaller company, sometimes you have to spend more. When you get merged, you will get the synergical benefits. So for that particular purpose, it got merged. But that other company was continuing as a division of the Berger Paints Limited. Because of that, what happens is that the catering of the company to different markets would kept intact. Sometimes it may so happen you need to have licenses or you might be starting some new companies. Especially in case of Reliance, what used to happen is whenever you take up new businesses, you can't utilize the same company because it is having some legacy issues, some kind of a baggage it may be having it. You need a clean company to start something. So you will be incorporating those companies. And when you incorporate that, sometimes it may so happen those companies will become over a period of time gigantic companies. Say, for example, in case of Reliance, if you see that retail, we have started one retail verticals and that's to go on incorporating the companies because for different purposes, you need different companies. Same as the case with telecom. When we started Geo, then there are other set of companies were there. So for that, you need to incorporate the companies. If you see that recently Reliance has demerged its financial services into Geo Financial Services. Why it is? It is because to monetize the asset. Over a period of time, it so happens that what you have started today, it will become a giant over a period of time. That point of time, if you want to get the real valuation of that particular business, you need to demerge that. That's why Geo Financial Services has been demonetized by way of a demerging. Maybe one point of time, retail may happen with retail, it may so happen with even telecom company also. If you remember that in the year 2005, when I joined Reliance, at that point of time, the demerger was going on. That time the strategy was different because the distribution of assets were to take place because sometimes it may so happen, you may have a family reasons also. When that next generation step into that point of time, who will be handling which type of businesses? The skill sets of the owners might be different and the skill sets of the leaders might be different. So for that particular purpose, you have to do it. So if you see that point of time, there were different verticals were there in the Reliance itself. So it was demerged into 4 resulting companies. One was an electricity company, one was a financial services company, one was a natural gases company, and one more was there like that. There were into 4. And of course, the groups got separated. Sometimes it may so happen you have to do corporate restructuring for the purpose of taxation also. If you want to have tax efficiency, you need to do this. So there are gone n number of things may be there. It all depends upon at the end of the day. It is a business strategy and most of the times corporate restructuring takes place for the benefit of the company, for the benefit of the shareholders, for the benefit of all the stakeholders. Here I give a pause and then I request Bala to say a few words. After that, Nayan will make the presentation and wherever and whenever I require, I will step in that part. Thank you.
Good morning to all of you. I have a great pleasure in welcoming you all for this webinar today, which has been going on for the last over 2 months or so. And we also have Suhas, who is a very vibrant, highly academically qualified, with a varied experience, starting from bank and coming to CS profession. I see him a very great learning experience. He has come with a rich experience. Because he has handled these matters, I am sure that he will be sharing his experience. Coming to this topic, already our panelists have already given a lot of things in the topic. I only got to say one thing. In the 1956 Act, when the section 390 to 394, that's an old section, which was actually there. Initially, it was thought, probably the sections are actually there to revive the sick industrial company, because revival of the company, when it is going to liquidation person, we can revive the company. But somehow what has happened is the success of revival of the sick industrial company has not taken so much, but on the contrary, it has become a boon to the corporate that anything and everything which cannot be done by utilizing many sections in the Company Act can be done under the single window clearance under these sections. So if you want to do anything, you don't have to do separately compliances under each section. Because once you form a scheme of arrangement, a scheme of restructuring, whatever you call it the name, ultimately when you go there, even the capital reduction tax, you know, not to comply separately the whole section under 100, and it all comes along with the single window clearance by one single order by the appropriate authorities, which was earlier High Court and now today at the NCLT. So really speaking, this particular section that is today 230 to 234, which has been the whole section of 390 to 394, is actually really a boon to the companies. In fact, when we had a recession period somewhere in the year 95 to 97 or something, when Ratan Tata was telling that the turnaround will take place, which did not come through at that time, I remember many companies, because especially that was a globalization, liberalization, which started actually, many companies consolidated their operation, done a lot of restructuring by utilizing these sections during those period actually. It was one of the golden period. People have a consolidated operation. He has restructured the operation. All these things happen. Lot of merger, lot of demerger, lot of slum sale, lot of sale off. All the things which has taken company has actually brought in very efficient managing teams. That is what it has provided actually. Even today, that is proving the same thing. We see lot of scheme of arrangement, etc. Under this, anything and everything can be done. Because you can enter the scheme of arrangement with the creditors, you can enter the scheme of arrangement with the debtors, you can enter the arrangement with the own shareholders also if you want to reward them back, etc. And all the things. All the things are all a very good. And especially the listed companies, when it's come to that, because it is the minority shareholders, especially the people, small investors who put in their money, the regulators are very much concerned about it. That is why regulation 3737A becomes important. It works along with the Companies Act only, but the thing is there are various restrictions, various exemptions, etc., which has been granted. I think which Nayan is actually taking through this. Really speaking, this is one of the, I say, finest provision in the Companies Act, which is acting as a boon to the companies. They can actually do to become efficient. That's all I would say here. I'll ask Nayan to proceed on this.
We always hit that three-digit number of the participants by the time the presenter presents the program. Today also we have 102 people right now. So Nayan, it is high time for you to start. I think.
Yeah. Thank you, Bala sir. Thank you, Sudhakar sir. So good morning, everyone. Ladies and gentlemen, esteemed guests, and the participants. I extend a warm welcome to each one of you to this insightful webinar on unlocking the opportunities through the scheme of arrangement and sale of and disposable of undertaking under the SEBI LODR regulations. I am CS Nayan Handa, a proud Delhi partner at Mehta Mehta. So it is a truly an honor to have you all join us today as we delve into the intricacies of the corporate strategies that can shape the future of the businesses. So before we proceed, I would like to extend a heartfelt gratitude to the visionaries behind Mehta Mehta. So our founding partners, CS Atul Mehta and CS Dipti Mehta. So their leadership and commitment have paved the way for us to explore and share the knowledge on such a crucial topics. So as we embark on this journey of exploration, collaboration, and learning, so let me share a quote that encapsulates the essence of our topic. In the realm of corporate evaluation, opportunities often lie in the strategic rearrangements of assets. Though well-crafted schemes and meticulous disposals, business can transform the challenges into the gateway for growth. So our distinguished speakers and experts will shed a light on the key aspects, providing the invaluable insights and practical perspectives. So I encourage you to actively engage and ask questions and make the most of this opportunity to enhance your understanding of these crucial elements in the corporate governance. So before proceeding, let's remember that knowledge is not just a power, it's a catalyst for the transformation. So as we uncover the intricacies of the scheme of arrangement and sell and disposal of undertaking under the SEBI LODR regulations today, may you find inspiration and actionable insight that will, propel your organizations towards the unprecedented success. Once again, a heartfelt welcome to each one of you. Let's make this webinar a collaborative space for learning, sharing, and unlocking the opportunities that will shape the future of our business. So in this presentation, we kick off our exploration by shedding the light on the intricacies of scheme of arrangement. So as its essence, a scheme of arrangement is a legal and the regulatory mechanism, which is, empowers companies to strategically structure their capital, operations, or overall structure. So achieved through a court-approved government agreement with the stakeholders. So this framework plays a pivotal role in, optimizing the business efficiencies, financial health, and the long-term growth. So the component integral to a scheme of arrangement, it is, encompasses the modification of share capital, which includes the consolidation, division, or conversion. So the debt's restructuring to ensure the financial stability. The realignment or streamlining of the business operations for improved efficiency. So this legal avenue, provide a business with a strategic flexibility to adapt to the dynamic market conditions, optimizing their financial structures, fundamentally, unlocking the shareholders' value to bolster the competitiveness. So as we continue, our focus now shifts to the diverse landscapes for the corporate actions. So these actions plays a very pivotal role in shaping the trajectory of a company, which is influencing the structure and determining its financial health. So that diverse range of corporate actions includes merger and amalgamation, demerger, buyback, divestitures, bonus, and right issues. So these corporate actions, they have the strategic implications like market positioning, capital structure optimization, and shareholders value creation. Understanding these corporate action is very pivotal for strategic decision making, and each action holds a very unique opportunities and challenges and shaping the future trajectory of an organization. So let's explore how these strategic moves can be harnessed to unlock the opportunities and foster the sustainable growth with some examples. Here, this is one of the scheme which is included in the corporate action, that is merger and amalgamation. So merger and amalgamation is bringing together two or more companies to form a new entity, which is in a corporate transaction. So in which two or more companies combine to form a new entity or integrate their operations into the existing ones. So which is compelling with the example we can understand. So imagine there is a company A, so which is a leading player in the technology sector and with the vision to expand its market presence globally. Recognizing the potential for growth and collaboration, so company A identifies company B, which is a smaller, boosting complementary technology and standing as an ideal merger candidate. So through a meticulous crafted scheme of arrangement, company A and company B, they embark on a journey of a strategic collaboration. So the company A, with its market influence and resources, join forces with company B. So company B is capitalizing on its, specialized technology. So this strategic union combines a synergy that go beyond the sum of their individual capabilities. So here in this example, you can see the company's A ambition to expand globally and align, seamlessly with the company's B specializations in technology. So the merger not only, consolidates their strength, but also position them as a formidable force in the technology landscape and unlocking the new market and the growth avenues. So this real world scenario, showcase how a scheme of arrangement, can be powerful catalyst for companies aiming to strengthen their market position, enhancing their capabilities, and create a value for the stakeholders. So as we explore this example, so considering the strategic implication and opportunity that merger and amalgamation can offer to the organization.
A practical example would be LTI Infotech plus Mindtree is equal to LTI Mindtree. That will be your
Yeah.
A plus B is equal to A plus.
Here, just Nayan, 1 minute, just go back to the previous slide.
Yeah.
See, in this case, sometimes a question may arise that, suppose, when the company A, which is a smaller company, got merged with the company B, why they have to get merged into AB? Why not A gets merged into B? Because B is already a well-established company. Sometimes it may so happen that companies are identified with its businesses. And suppose that even if you are starting a new line of business, still the impression may not be there. You will be identified with that particular mark only, Just like in, if you see in our families also, Chotu always be a Chotu only. He will never grow. So same is the case in the businesses also. Sometimes it may so happen that you have to re-establish your identity. That is the reason here when A and B are getting merged into another company, that is AB. So because the AB will be projected into a new, completely new set of businesses, a new set of orientation, maybe a logo, maybe everything, So people will accept that even if as B, even if you do whatever it may be, I think what are the example I'm giving you, if you know that very well, it is the right example. Chotu will always be a Chotu in the family. Even if he got married, he got children, grandchildren, but still he will be considered as a Chotu only. That is the reason for this thing. So B will be always B. So to lose its identity and get a new identity is required sometimes as a strategy of business. Yeah. Go ahead.
So now let's explore the strategic realm of demergers, which is particularly focusing on the spin-off and the split-ups. So before that, let us understand what is demerger basically. Demerger is also known as a spin-off, which is a corporate strategy, you can say, in which company separated its part of a business asset or subsidiary into the new and which is an independent identity. So here you can see the example we have crafted here,
Yes.
like there is a company which is ABC. It's a conglomerate with the diverse business units, which is illustrating how demergers can enhance their focus and the shareholders' value. So imagine this company ABC, a conglomerate, which is having a portfolio which is spanning the various industries and recognizing the need to enhance more focus and unlocking the shareholder value. So ABC has opted for demerger provisions under the SEBI LODR regulation. So this strategic move, company ABC embarked on a journey of unbundling and separating its diverse businesses into the three distinct entities, which is each entity was tailored to concentrate on a specific domain. So one entity focused on manufacturing and let's say leveraging specialized expertise and resources, and the other two entities concentrated on the retail and services respectively. So aligning with the unique strength and the market opportunity with those sectors. So this demerger strategy, allowed each entity to operate independently with a heightened focus on their core strengths and competencies. And so there, the shareholders witness the creation of three specialized, entities. So each will have their own distinct market and they have their distinct space. You can see the demerger of company ABC serves as a testament to how this strategic unbundling can not only enhance their operational focus, but it also created a separate entity and for success in this their specific industry. So as in this example, considering this strategic advantage and the value creation that demerger such as spin-off and spill-off can bring, it can offer an organization to seeking into the optimize their portfolio and unlocking the hidden potentials. So in this segment, we turn our attention to the dynamic landscape of acquisitions and the takeovers. A takeover, an acquisition, basically it's a pathway to strategic growth by acquiring the assets or shares of another company, whether through a friendly merger or a potentially more assertive or hostile merger. So an acquisition, you can say it's a strategic move where a company procures the assets or shares of another entity, aiming to strengthen its market position, enhancing capabilities, or enter the new market. So this process can, be executed through the negotiations, mutual agreement, in a friendly merger, or in some cases through a more assertive approach, which is a hostile merger. And which they have implications like they after doing this kind of an acquisition, there is a market expansion, the capability enhancement will be there, and there is a diversification of business. And there are two type of acquisitions are there, that is friendly merger, and one is a hostile takeover. And a friendly merger can be the collaborative negotiation where both the parties agree to merge for the mutual benefits. And in the hostile takeover, it's a more aggressive approach, which is involving the acquisition of share against the wishes of the target company's management. So here in this slide, we can see the example, and considering the case that company X, which is a global pharmaceutical giant, let's suppose, with the vision to increase their product pipeline. So recognizing the potential for growth and innovation, so company X strategically decided to acquire company Y, which is a smaller biotech firm, which is renowned for its ground-breaking drug development. So through this acquisition, company X gained access to the company's Y's innovative research and development capabilities, and enriching its product portfolio and reinforcing its position as a leader in the pharmaceutical industry. So this strategic move exemplifies how this acquisition can be, a catalyst for growth and allowing the companies to leverage and specialize the expertise and unique offering of others to enhance their own capabilities. So as we explore in this example, like company X and company Y, so keeping in mind the strategic considerations involved in acquisition and takeovers, whether through collaborative merger or assertive takeover. So this strategic maneuver redefines the industry and shape the competitive landscapes.
See, here again, Nayan, I would like to add something. Say, for example, sometimes a question may come up, why acquisitions or takeovers? Suppose a company wants to expand its capacities, because considering the market, large market, they want to expand the capacities.
Yes.
So for expanding the capacities, there are two ways of doing it. One is the greenfield venture and one is the brownfield venture. So in the greenfield venture, what happens? Sometimes it may be very costly. Suppose, for example, to expand my businesses, if I have to set up my, other manufacturing facilities, I have to acquire land, I have to purchase plant and machinery, I have to set up the people. So many things are there. So these are all going to cost me heavily. Sometimes there may be some good companies which the valuations are very cheaper. So instead of setting up a new business altogether or expanding my businesses altogether, I propose to acquire those companies which are cheaper, and the valuation wise, they are very, very cheap for me to acquire that. So there what happens is, the smaller companies, sometimes for them, the question of survival may come. When the large companies are expanding its capacities, the smaller ones may not be able to survive. So sometimes what they will do is they voluntarily will go and give that control to the other, the bigger manufacturers or bigger, business entities.
Mm-hmm.
Sometimes it may so happen they may resist. When the resistance takes place, then what will happen is, if the larger ones, they may go for hostile takeover also.
Mm-hmm.
So hostile takeovers, they happen by exceptions, not by default. And sometimes it do happen. That's why it is up to the promoters whether you will resist the takeover or whether you will go along with the takeover. And it all depends upon again, the same thing. It's all completely business strategy over here.
Yeah.
Go ahead.
Yeah, also, sir, it can be a more of a traditional approach as well by entering into a simple share purchase agreement. The question of scheme would come in when we interpret the tax benefits and the stamp duty benefits which comes in with it. So even like you said, it's a very small player. We can also go ahead with a simple share purchase agreement or a BTA if there's a business transfer which is happening, and that's also a practice within the market which I've seen.
See, most of the times when we go for acquisitions and takeovers, they're purely for business purpose, not for tax benefits alone. Tax benefits will happen only when you are going for the merger, demerger, amalgamations and all. But as far as acquisitions and takeovers are concerned, to a large extent, they're always for future business expansion and enlarge your capacities and all. And similarly, you will go for an acquisition or you will go for a takeover, provided the availability in the market is the valuations are cheaper and the potentiality is there. Sometimes it may so happen if that discarded machinery is there, but still they might be having huge land banks. That land bank, I can utilize that. Say, for example, in case of a retail business also, sometimes you might have seen that, that Future Group and the retail group, how they have Reliance Retail and all those things. So these are all business strategies. And sometimes what happens is, as I was mentioning, when large business entities are expanding and they are going aggressively, for the smaller and medium-sized companies, they find it very difficult to survive and to sustain in the business line. So it is better at that point of time when you can't resist. So you just decide and start something of your own instead of going and when you are not able to compete, then what else you can do it? Sometimes competition may be very costly.
Right.
Yeah.
In merger and amalgamations, what happens is either one or two companies, they lose their identity, or both loses the identity, the new entity comes into. That's what it happens. But in the acquisition and takeover, by and large, what happens is the identity of the company remains. Because when an acquisition is takeover, as Sudhakar puts it, the smaller company, they already created the value, they already enjoying the brand name in the market, etc. and all this thing. The company which is actually taken over is run as it is, retaining their brand, retain their value and adding the value addition. That is what happens in acquisition and takeovers. Because most of the companies.
To give an example, just to give an example, Bala, I can say this thing also, like suppose I purchased a Mercedes for whatever the reasons it is. I thought a bigger car is good. After that, I realized that to maintain, it is a white elephant for me. To maintain itself is I have to sell myself. Instead of that, why not to resell it? So there is nothing but like this also. These are all purely business strategies.
Yeah, that is right. I agree with you. Because only thing is, I just say what is happening in this between the issues. That's it.
So one of the trends which I have noticed is like these big players, they buy they don't get into a scheme. They buy basically the share purchase, get into a share purchase agreement, buy the entire company, make it a wholly owned subsidiary, and then get into a scheme. So that you save time. The company, anyways, you own the entire company and it's your own wholly owned subsidiary. The process also becomes very easier to do it.
Yeah, correct.
Yeah, just to add that here, the merger amalgamation practical aspect. As on today, the recent what is practice in NCLT is that, especially in Mumbai, if it is only for tax planning, the same is not allowed. It is specifically asked, so in the scheme, you have to write the reason elaborately. So I suggest that please don't write, you have to give business reason, logical reason. If in addition to tax planning, try to avoid, though tax planning is legal, it's allowed, it cannot be questioned, but accept the practical situation. The court asks, what is the reason you are coming? And if the lawyer says, the counsel says that tax planning, then the series of questions, whether it is AMLA and various things they keep on and it will delay. So please put it more on administrative business part. Tax advantage can be a small portion, not the reason. If sole person, since long the NCLT started creating issue and it will be a problem. That was a practical part. Thank you.
Yeah, well said, Dipti.
Yeah.
Sudhakar, I have actually seen almost about 3-4 takeovers during my company secretary's period. As Dipti mentioned, this Fusiko India Limited I was working. I started with Fusiko India Limited when it was actually under the control of Greaves, which was actually taken over by Burma Castor. But the Burma Castor is taken over it. The company was run still with Fusiko India Limited only. Subsequently, another venture capitalist took over. Then again, it was running the same. Then again, the big giant, which you may be knowing, Visuous India, they are one of the metallurgical company. They took over this company. Even when they took over this company, the company's name retained as the same. They are actually running as their group company, division company, whatever you call it, etc. Still, it continued to be under the same name because they created the brand value in the market. And ultimately, they have the synergy advantages in combining the things. That is what they are getting a business advantage. Yeah.
Thank you. Nayan.
Yeah, thank you. So we are moving forward now.
Yeah.
So in this segment, we are shifting our focus to the another scheme, which is capital restructuring, which is a process that involves the significant changes which is made to the company's capital structure, representing the blend of the debt and equity, and to the finance operations and the investments. So understanding what is the capital restructuring, it is basically it's a proactive approach that companies undertake to optimize their financial structure, aiming to enhance their overall financial health and performance. So this involves the strategic adjustment to the mix of debt and equity and aligning it with the company's growth goal and the market dynamics. So the key strategies in capital structuring may be the debt repayment, equity issuance, and it can be the financial reorganizations. So there are some other benefits of doing this restructuring as well. Like after doing the capital restructuring, the company focus on the business growth. There is a business growth opportunity. There is a competitive alignment and employee productivity, and enhance the company finances. And moving forward, there is another scheme which is encompasses the various corporate actions, including the arrangement with the creditors. So arrangement with the creditor refers to the formal agreement or a settlement which is reached between the debtor and its creditor. So this arrangement is typically entered into the when debtor is facing a financial difficulty and unable to enter into when the debtor is facing financial difficulty and unable to meet its debt obligation in the agreed upon manner.
Are these more explored by the financial institutions? On a prima facie reading, it looks like. Sudhakar sir, if you had a point there. When it comes to arrangement with creditors and debtors and debt restructuring and planning and the non-performing assets being traded rather. So it's I believe the arrangements with creditors are generally done by the financial institutions.
No, actually, if you allow Sudhakar, can I?
Yeah.
Yeah, so it is, for financial industry that banks and all that, they have off and all that structuring. But as regards being in the current scenario, this is also observed by all the companies. In the sense, they discuss with them because the liquidity stress and liquidity problem creates the issue, and they have to work on this and the payment plan and asset disposition for liquidity purpose because of very strict regime of IBC. And not yet picked up, but pre-pack is a very beautiful thing which IBC has provided, where the company can offer the structuring and involve the independent insolvency professional, and the lender and the company can come out with the entire restructuring on prepaid plan, and it can be avoided insolvency. If implemented, it's kind of mutual understanding and mutual discussion. It comes out very well. So this happens even now very regularly in other companies. Though you are right that it is extensively used by financial industries, but it is picking up in other industries.
Thank you.
You are right, actually, Dipti. In fact, there are companies who are, they are lagging behind the payment. They are not able to make the payment. They are actually, if they have to incur the heavy payments, etc., they run into the bankruptcy situation. What it is seen also, they also negotiate with the debtors so that what happens, they reschedule the payment. They convert the larger payment into small payment. Even they take the interest rate reduction, etc., and other thing, and that restructuring is done even by the other companies also. As you rightly say, yes, it is more seen in the financial companies. Other companies, it is seen less, but other companies, they have been also doing it on this.
Yeah, Kinjan Misri has mentioned our partner, that example of SR oil. Yeah, that's,
Thank you.
So,
yeah.
so this financial strategy is not just about the resolving the outstanding debts. It's a pathway basically to navigate the challenges with the dignity. So by avoiding the bankruptcy, it safeguards the interest of both the debtors and the creditors. So fostering an environment which is conducive to financial rehabilitation. So in this intricate, the dance of finance and arrangement with the creditors emerges as a grateful waltz and providing a melody of stability and the resolution in times of financial challenge. So thank you everyone for your attentive presence. So we are now navigating to the regulatory maze of the SEBI compliance, SEBI LODR compliance. So building on our understanding of the various scheme of corporate actions, so let's now shift our focus on the regulatory backbone that governs these strategic moves, the Securities and Exchange Board of India, the listing obligations and disclosure requirements regulation. So in this, let's consider like why does the compliance matter? So we can discuss this here. Let's consider it the SEBI LODR as a compass that ensures our strategic path, which is aligned with the highest standards of transparency and the governance. The transparent and the accurate disclosures coupled up with the adherence to to improve the mechanism, safeguard the interest of the shareholders, and foster the fair and the ethical corporate practices. So as we delve into the regulatory landscape, it is very crucial for us to recognize that the understanding the SEBI LODR regulation is not just an obligation, and it's a commitment to navigating the complexities of the corporate transactions with integrity. Now, armed with the deeper understanding of the various corporate actions, let's unveil the nuances of the SEBI LODR compliances. So here is Regulation 37, which serves a crucial guidepost, that within the broader framework of the SEBI LODR, and it outlines the specific disclosure requirement related to the corporate actions, aiming to ensure the transparency and the timeline dissemination of the crucial importance of the stakeholder. So the key components of Regulation 37 says there is a disclosure of the corporate action, and there is a materiality criteria, and one is immediate reporting. So understanding the specific of the Regulation 37 is very paramount for companies to navigate the SEBI LODR landscape. And here you can see a crucial step which involves, seeking the prior approval before moving to the NCLT to file a petition for actions like merger and amalgamation or restructuring. So before a listed company proceeds with the filing of a petition at the NCLT, pivotal requirement is to obtain the prior approval from the stock exchange. So this approval process serves a foundational step, which is ensuring the regulatory compliance and setting the groundwork for the seamless corporate restructuring. Now we are going to understanding and adhering to this approval process, which is fundamental for companies to undertaking the significant corporate action. So moving forward, we are going to understand the step-by-step procedures of how to apply for the approval and how it is approved and as per the regulation and mentioned in the regulation, which is follows. So as per Regulation 37(1) of the SEBI LODR 2015, which says without prejudice to the provision of Regulation 11, the listed entity desirous of undertaking a scheme of arrangement or involved in the scheme of the arrangement shall file this draft scheme of arrangement, which is proposed to be filed before any court or tribunal under section 391 to 394 and 101 of the Companies Act 1956, or under section 230 to 234 and section 66 of the Companies Act 2013, whichever is applicable, along with the non-refundable fees as specified in Schedule 11 with the stock exchange for obtaining the no objection letter before filing such scheme with any court or tribunal in terms of requirements specified by the board or a stock exchange from time to time. Here you can see this, as per Schedule 11, the listed entity shall, along with the draft scheme of arrangement, remit a fees at the rate of 0.1% of the paid up share capital of the listed transferee or resulting company, whichever is higher. So post the sanction of the scheme, which is subject to the capping of 5 lakh rupees. So as we, going for the draft document of scheme of arrangement, it is crucial to understand the other stipulated guidelines by the regulations by the SEBI LODR. So under this regulation 37.2, which is, talking about the obtaining the no objection letter. And the regulation says the listed entity shall not file any scheme of arrangement under section 391 to 394 and 101 of the Companies Act and the section 230 to 234, whichever is applicable with the court or a tribunal, unless it has obtained the no objection letter from the stock exchange. So before filing any scheme of the arrangement, so under this relevant section of the Companies Act, the listed entity must secure a no objection letter from the stock exchange. So this step is a foundational, ensuring the alignment with the regulatory requirements. And the second regulation, another regulation 37.3 of the SEBI LODR, which specifies the general compliance obligation. It says the listed entity shall place the NOC, no objection letter of the stock exchange before the court or tribunal at the time of seeking approval of the scheme of arrangement, providing that the validity of the no objection letter of stock exchanges shall be 6 months from the date of issuance, within which the draft scheme of arrangement shall be submitted to the court or tribunal. In addition to the specific, the no objection letter becomes a very, you can see here, it's a very crucial document which is to be presented before the court or a tribunal when seeking approval for the scheme of arrangement. So it's imperative that the validity of the no objection letter from the stock exchange is within 6 months from its issuance. And in the regulation 37.4 of the SEBI LODR, it says the listed entity shall ensure the compliance with the other requirement as may be prescribed by the board from time to time. In this edition, there is a specific requirement that the listed entity must ensure the compliance with the other regulation, which is as may be prescribed by the SEBI board from time to time. So reinforcing the commitment to adherence and responsible corporate law. In regulation 37.5, upon sanctioning of the scheme of the court or tribunal, the listed entity shall submit the document to the stock exchange as prescribed by the board from time to time. Upon the, here it says, it is talking about the post-approval documentation, and upon the court or a tribunal sanctioning the scheme, the listed entity is obligated to submit some prescribed documents to the stock exchange, and this ensures the transparency and completes the regulatory cycle. So understanding and diligently adhering to these regulation condition is paramount, not just for the legal compliance, but for establishing a foundation of trust and transparency. So there are some exemptions as we navigate through the other slide. Regulation 37.6 is exemption for the wholly owned subsidiary merger, and which says nothing contained in the regulation shall apply to the draft scheme that solely provide for the merger of wholly owned subsidiary with its holding company, provided that such draft schemes shall be filed with the stock exchange for the purpose of disclosures. Regulation 37.6 provides an exemption for a draft schemes, which is solely focusing on the merger of wholly owned subsidiary and its holding company. So in such a cases, the listed entity is still required to file these draft documents with the stock exchange for the purpose of disclosures, ensuring the transparency despite the exemptions. Under Regulation 37(7), which is also an exemption for restructuring in the resolution plan, and as per the Regulation 37(7), it says the requirement as specified under this regulation and Regulation I-4 of these regulations shall not apply to the restructuring proposals which is approved as a part of resolution plan by the tribunal under Section 31 of the Insolvency Code, subject to the details being disclosed to the recognized stock exchange within 1 day of the resolution plan being approved. So here in this 37(7), it is introduces an exemption for the restructuring proposals approved as a part of a resolution plan by the tribunal under Section 31 of the Insolvency Code. So, however, a crucial condition is that it details, of the restructuring proposal must be disclosed to the recognized stock exchange within 1 day of the resolution plan being approved. So this swift disclosure ensures the timely communication and the transparency in the restructuring process. Understanding this announced regulation, it is very vital for listed entities to navigate the scheme of arrangement landscape. So while certain exemptions are provided, the overarching themes, remain a commitment to the transparency, timely disclosure, and the regulatory compliances.
Getting the no objection certificate, any time limit is actually prescribed or something like that? Because when we gone for the scheme of arrangement along the shareholders, I think way back, very long time back, that time we've been told actually 1 month before we filed the actual application to the court, that time it was a high court. So 1 month before that, we'll have to actually file with the stock exchanges. So that
Yes,
is what we did actually. After
Yes.
a month, when we went to the no objection certificate to the stock exchanges, that stock exchange that you can actually file the application, etc. We will actually issue the no objection certificate. That is what it has happened. And by the time when the matter has come, we were listed that time, both the stock exchanges, NSE and BSE. Not only that, we are also listed in the regional stock exchanges. Those time it was there in many other stock exchanges. We were actually listed in Calcutta Stock Exchange, Madras Stock Exchange, and Pune Stock Exchange. Everywhere when we went, we have been told, have you got the no objection certificate from your regional stock exchange, that is Pune Stock Exchange. Then once we got that, then based on that, all the other stock exchanges are actually issued. But we went to the NSE, first you get from BSE. That is what it has happened. But anyway, ultimately we got it. And today in the regulation, any time limit, etc. is there or something like that? Or no objection certificate, they will issue in how many days, etc.
Nala, it was not like that. See, earlier, prior to listing regulations, under the old listing agreement, we used to have a clause 24F.
Yeah, I know.
That 24F is not an NOC. It was actually a kind of in principle approval for listing your securities. Under the old listing agreement, there was no requirement to get NOC for your scheme of arrangement. That scheme of arrangement, NOC, has come only in the listing regulations post 2015. And this NOC you have to obtain before even you file the application with the NCLT. So unless until you have the NOC with you, you can't even file the your application with the NCLT, because NCLT first and foremost, in case of a listed companies, they are going to ask is, have you received the NOC from the stock exchanges? Number one. Number two, at the same point of time, still that 24F clause is there in the shape of 107. In fact, yesterday I was talking to Nayan. Somehow it was there in my mind. 24F is under the listing regulations, which is not so. Subsequently, I could check that it was only 107. In the 107 also, what happens is that you have to have in principle approval from the stock exchanges for listing of your securities, because post amalgamation, merger, demerger, whatever it is, you are going to issue securities. And those securities you have to go for listing. For that purpose, unless until you have in principle approval, you will be in trouble. So before Nayan switch over to sale and disposal of undertakings, I would like to say 2-3 things. Number one, if you see this merger, amalgamations, demergers, entire corporate restructuring procedure, it is completely procedural oriented. Any wrong step anywhere, it may damage your whole plans. One of the, suppose whatever the approvals are required, sometimes you may, if your companies are huge companies, you require even CCI approval, Competition Commission of India's approval you require. So you have to be very clear. And similarly, sometimes it may so happen insurance companies, you require IRDA approval. Banking companies, you require RBI approval. NBFC companies, I meant to say. Telecom companies, you require TRI approval. So regulatory sectors require regulatory approvals. So as a company secretary, when you are working for companies, it is always advisable to have a consultant along with you. That consultants, earlier what used to happen is you were imperatively to have a legal consultant, because only the lawyers could represent your case before the courts and not the practicing company secretaries, which is not the case now, because in the NCLT, even the practicing company secretaries can go and represent. That's why it is always advisable to have a friendly consultant, whether it is a lawyer or a PCS firm or a chartered accountancy firm, it is up to you. But at the same point of time, while engaging the consultant, yesterday also we were discussing this, you cannot, the company secretary who is in service, he cannot in a hands-off position. He cannot say, okay, I engaged a consultant, now the consultants will take over everything. Ultimately, you have to have the levers in your hand and you have to drive. For that, definitely you need to have your own set of understanding, the knowledge, everything about it. Because consultant is always a consultant and you are the person who is owning the company. So you have to take the ownership, and consultant, you cannot give your ownership to the consultant.
Yeah,
Okay.
you are
So
absolutely
this is what I
right.
thought I will add it to that.
Yeah, you're absolutely right, Sudhakar. In fact, when we went for the merger of some toll companies in Vodafone Group, as you rightly said, the sectoral approval from the telecommunication people, because the shareholding limit which was prescribed was exceeding, so that approval was required. Unless that approval was produced, no amalgamation approval was coming through the incident. That is true.
So just to add one more point from the practical experience I've had, over and above what Sudhakar has said, this is also an acknowledgement towards how amazing the people in our profession are. I have never found a single company secretary till date who has told me, no, I will not help you when I've gone to them. The least they have told me is like, I haven't worked on it, but I'll at least find a contact for you who's done it. What I'm trying to say here is, scheme is a public document. You know who has done it in the past, which company has the similar line of business you're into. You pretty much know who has worked on it. You can always find the contact of the person who has taken up there. Speak to him. They say smart learn from their mistakes, smarter learn from others' mistakes. Discuss with them all that with a similar line of business, all that they have gone through. It's pretty sure that you're going to face that in your journey. Speak to them, have the precautions in your place. That also adds a little value add over and above the consultants and your own self preparation for a deal.
Yes, Nayan, go ahead.
So now we are moving forward in another segment in which we are going to explore the strategic realm of sale and disposal of undertakings, which is a process that involves the sale or disposal of an entire business or a significant part of it. This strategic move, can take various forms, either as a part of scheme of arrangement or through mechanism like slump sale or a business transfer agreements. Sale and disposal of undertaking, it's encompasses the strategic decision to sell or dispose of the business entity, whether it is be the entire operation or a substantial part of it. So this can involve the sale of asset, transferring of contracts, handover of control, and ownership to another entity. So there are some key aspects of sale and disposal, like asset sale, which involves the selling of a specific asset of the business, and a contract transfer, the transfer of existing contract to the acquiring entity. Change in control by shifting of operational control and the ownership to the new entity. There could be many reasons for undertaking the sale or disposal, like the company wants to go for a strategic reorganization, means aligning business operations with the strategic goals, or maybe they want to focus on the core business activities like streamlining the operations to concentrate on the core competencies. Maybe they're going for the financial restructuring, disposal of underperforming assets, those, shedding away those assets which is no longer contributing to the overall performance of the company, eliminating of the non-core asset by enhancing, more focus on the business. So understanding the dynamics of the sale and disposal of undertaking, which is essential for a companies to seeking the strategic reorganization and the value enhancement. So this move can unlock the new opportunities and contribute to the long-term sustainability. So sale and disposal of undertaking, it is regulated according to the section 181A of the Companies Act and regulation 37 of the SEBI LODR regulations 2015. So let us understand the meaning of undertaking. Section 181A part 1 undertaking says, undertaking shall means an undertaking in which the investment of the companies exceeds 20% of its net worth as per the audited balance sheet of the preceding financial year, or an undertaking which generates the 20% of the total income of the company during the previous financial year. In the meaning of substantially the whole of the undertaking is section 181A subsection subclause 2, the expression, the substantially the whole of the undertaking in any financial year shall mean 20% or more of the value of the undertaking as per the audited balance sheet of the preceding financial year. So this section here refers to a numerical parameter. So what should be considered as an undertaking, and however, before testing the numerical parameter, one needs to assess whether the assets to be disposed of it as at all an undertaking. So for this, such asset should be capable of being identified as a unit, has asset and liability of its own discrete of the listed entity. Once this qualitative criteria is met, undertaking shall covered under section 181A and regulation 37A if the investment of the company in such undertaking is more than 20% of its net worth, or the undertaking generate at least 20% of the total income of the company. So the term sale and disposal of undertaking typically refers to the process of selling the disposable of assets. Now here we are moving to the sale, lease or disposal of an undertaking outside the scheme of arrangement under regulation 37A which came into the force with the immediate effect, that is from June 14, 2023. As per regulation 37A1, it says a listed entity carrying out the sale, lease, or otherwise disposal of the whole or a substantially the whole of the undertaking of such entity, or where it owns more than one undertaking of the whole or substantially the whole of any of such undertaking, shall take a prior approval of the shareholder by way of resolution and disclose the object of and commercial rationale for carrying out such sale, lease, or otherwise disposal of the whole or substantially the whole of the undertaking of the entity, and the use of proceeds arising therefrom in the statement annexed to the notice to be sent to the shareholder. Provided that such a special resolution shall be acted upon only if this vote cast by the public shareholder in favor of the resolution exceeds the vote cast by such public shareholder against the resolution. Provided further that no public shareholder shall vote on the resolution if he is a party directly or indirectly to such sale, lease, or otherwise disposal of the whole or substantially the whole of the undertaking of the listed entity. And for this purpose, regulation, the term undertaking and substantially the whole of the undertaking shall have the same meaning which is assigned to them as under the clause A of subsection 1 of section 180 of the Companies Act 2013, which we have discussed in the previous slide. And the provision of this regulation shall not be applicable where the sale, lease, or otherwise disposal of the whole of the substantial, the undertaking of a listed entity by virtue of covenant covered under an agreement with the financial institution, which is regulated by or registered with the Reserve Bank of India or with the debenture trustee registered with the board. Here under Regulation 37(2), the requirement as specified in Regulation 1 shall not be applicable for sale, lease, or otherwise disposal of the whole or substantially the whole of the undertaking by a listed entity to its wholly owned subsidiary whose account are consolidated with such a listed entity. So provided that prior to such wholly owned subsidiary selling, leasing, or otherwise disposal of the whole or substantially the whole of the undertaking received from the listed entity, whether in whole or in a part to any other entity, such listed entity shall comply with the requirements which is specified in sub-regulation 1. For this, the explanation, the provision of this regulation shall not be applicable where the sale, lease, and otherwise disposal of the whole or substantially the whole of the undertaking of the listed entity is by virtue to covered under the agreement. So we can say the disposal other than by way of the scheme of arrangement has been, regulated, which is accordingly regulated to the section 181A of the Companies Act, which requires the approval of the shareholders by way of the special resolution. So the SEBI has prescribed an approval requirement in this regard by way of introducing the Regulation 37A, which is amended in June 14, 2023, that requires the entities to follow a stricter regime for the disposal of the undertaking. So this mandates an approval from the majority of the public shareholder who are not interested in the transaction. So disclosing of the object of the transaction, commercial rationale, and the use of the proceeds arising from such transactions. So while there is an exemption provided in a case of a transaction with the wholly owned subsidiary, the approval regime will apply in case of disposal of undertaking by such wholly owned subsidiary or any reduction in the shareholding in the wholly owned subsidiary subsequent to the transfer of the undertaking. Here in this context, we can see the listed company's disposal of an undertaking regulatory go beyond the special resolution, which is mandated by by section 181 and regulation 37A. And here regulation 37A specifically demands the approval of the public shareholders uninvolved in the transactions, only vote from such eligible public shareholder who have no direct or indirect interest in the sale. So in addition, you can say for this additional approval process, which complements the special resolution and promoters are entitled to vote. So it is noteworthy that this approval criteria, while it may appear similar, it is very different from the requirements for appointment of independent director, which is stipulated in regulation 25(2)(a) of the listing regulation, or under regulation 37 in the case of a scheme of arrangement. So this approach underscores the importance of distinct consideration in different corporate process and ensuring the transparency and safeguarding the interest of the diverse shareholders. So now moving forward, we are going to discuss the cases of entities which have listed their specified securities and they want to issue the draft scheme of arrangement, which shall follow the provisions of Regulation 94 of the SEBI LODR 2015. So this approval process.
Nayan, there is certain comments, which is just comments, no question in the chat box where people has just mentioned. So if any panelist wants to comment.
Yeah, I will read out actually.
Yeah.
Valuation of the assets and the liabilities to be transferred at arm's length pricing, etc., should also be considered in such a decision making. That is one thing. And the second thing is there. Somebody is put up here. In case of the global acquisition from the overseas, there is a cross-border transaction. Then timing of the announcement of the such acquisition, that is reporting to SE's media, stock exchanges, media, etc. The approval of the overseas regulation are also crucial, like European competition laws, approval under US securities laws, etc. Yeah, you are actually right, because as Sudhakar puts it, he actually mentioned it in terms of the sectoral approval, etc. and all this thing. In case of the cross-border approval, if they are governed with the other regulations, and one has to actually comply with the regulation which are applicable to the companies there. You are very much right actually here. Income tax implication
No,
of
this is actually, see, if I am not wrong, what Mr. Suresh is mentioning is with regard to Regulation 30 approvals. He was talking about the intimations what are to be given to the stock exchanges. It should be a simultaneous one. There should not be a time gap. That is what he is mentioning. That is, as far as the Regulation 30 is concerned, that has nothing to do with Regulation 37 or 37A.
income tax implication of the demerger sale disposal undertaking should also be considered, including the tax legacies. Of course, Kinjal has actually pointed out the SR oil for the financial restructuring, which we have discussed about here. And again,
Yeah, I think
Bala,
that,
Bala, just one thing, see, as far as the income tax implications are concerned, definitely, as I was mentioning, when you go for amalgamations, mergers, demergers, corporate, any other corporate restructuring proposals, not necessarily always the business is considering the tax implications only. Majorly, they consider the strategical wise, about the business point of view or strategy point of view, whether it is required or not required. At the same point of time, you cannot ignore the tax implications. Any kind of distribution or consolidation of assets is going to have its own tax nuances are concerned. Sometimes it may so also happen that for the purpose of tax advantage, also people go for corporate restructuring. As Dipti has rightly mentioned, when you are going for that, any kind of a scheme, you have to give the objectives of the scheme. That point of time, you cannot merely say that to ensure the tax efficiency, if you give that, that scheme may not get through. So you need to camouflage that. Definitely, they will see whether any loss of revenue to the government when the scheme is going to get approved. That time, the approval authorities will definitely look into the aspect of whether any kind of loss of revenue is there or whether any kind of tax evasional issues are there. And if it is so, definitely the applicants will be questioned about that and they have to justify that if at all it is there. Suppose on one side you are going to lose the tax advantage, the revenue loss may be there to the government, but on the other side, when the business flourishes, the government will equally get benefited. So that is what the argument, how that business entities have to give the justification for that corporate restructuring.
you are actually right. In fact, the tax is actually an incidental which is going to arise out of any transactions. There is no go about it. The only thing is, yes, with reference to the tax planning and availing the facilities which are available, one has to give the aspect to that only, but the scheme itself cannot be based on the tax. As Dipti has put it very clearly, if the scheme is actually for the purpose of only tax purposes, etc., definitely it will not get through. She also mentioned in Bombay in Bombay NCLT, if it is a tax, they don't approve at all. That is there. You want to add anything, Suhas?
yeah, I think that is all, right?
What more is there?
No, I was also thinking on the even the stamp duty point of view, because that being probably the second highest revenue which a state government rather gets from a corporate after the corporate tax itself, that also gets into consideration.
Yeah, when you talk about the tax amount of payment and the issue of the securities, I remember long time back, maybe 2-3 decades back, people, although having a register office in Maharashtra, they all choose to issue the securities holding the board meeting at Delhi because of to pay the stamp
Correct.
duty.
Correct.
Yeah.
So the government is not gonna spare that revenue part and approve it, because like I said, after the income tax from corporates, next biggest revenue which they levy from the corporates is the stamp duty. So that also will come into picture.
If a listed
There is a one question I
Yeah.
was.
if a listed entity is giving a consent of the amalgamation of its unlisted non-material subsidiaries to a group company having a value more than 10% of the listed entity consolidated turnover and a related party transaction requiring approval of the listed entity of the shareholder. Of the listed entity is record. That's what they're asking.
This is not a related party transaction at all, because you are not entering into any transaction with any related party. You are just giving a concurrence of, you are giving your approval. And that also that approval is giving, you are not giving a specific approval. You are giving an approval along with all other shareholders. So this is number one, first and foremost, to my knowledge, this is not a related party transaction at all. At the same point of time, if at all it is going to be an RPT also, based on the facts and figures, that point of time also that it is not, I mean, it is not falling under that merely giving an approval is not a transaction at all.
Yeah, you are absolutely right. If there's no imagination, it will attract the related party transaction. Yeah, I think that's all I think for the time being.
Yeah, Nayan, you can.
Yeah, thank you, Paul. So now we are going to discuss about the cases where the entities have, specified their specified security and wants to issue a draft scheme of arrangement which will follow the provisions of the Regulation 94 of the SEBI LODR. So the approval process for the scheme and transactions involves the seeking consent from the regulatory authority, and it requires the meticulous planning and effective communication as specified herein. Regulation 94 of the SEBI LODR, it's talk about the procedure for the approving the draft scheme of arrangement as prescribed below. So the designated stock exchange on receipt of the draft scheme of the arrangement and the document which is prescribed by the board under Regulation 37(1) shall forward the same to the board in the manner which is prescribed by the board. Under Regulation 94(2) of the SEBI LODR, the stock exchange shall submit to the board no objection letter on the draft scheme of arrangement after ascertaining whether the draft scheme of arrangement is in a compliance with the security laws or not. The no objection letter shall be submitted within 30 days of the receipt of the draft scheme of arrangement, or within 7 days of the date of receipts of the satisfactory reply on clarification from the listed entity or opinion from the independent chartered accountant, if any, sought by the stock exchange, whichever is applicable. According to this, regulation number 94, sub-regulation 3 of the SEBI LODR, it says the stock exchange shall issue the no objection letter to the listed entity within 7 days of the receipt of the comment from the board, after suitably incorporating such comments in the no objection letter. So provided that the validity of the no objection letter issued by the stock exchange shall be 6 months from the date of issuance. As per Regulation 94, Sub-Regulation 5 of the SEBI LODR, the stock exchange shall bring the objections to the notice of the court or a tribunal at the time of approval of the scheme of arrangement, if there are any. So according to the Regulation 94, Sub-Regulation 5 of the SEBI LODR, upon sanctioning the scheme by the court or a tribunal, the designated stock exchange shall forward its recommendation to the board, document submitted by the listed entity in the terms which is prescribed in sub-regulation 5 of the Regulation 37 of the SEBI LODR. Now here comes the another case when the draft scheme of arrangement and scheme of arrangement, it is in case of the entity which have listed their specified non-convertible debenture securities or non-convertible redeemable preference shares. So under this, the approval process for the scheme and transactions, it involves the seeking consent from the regulatory authority and requires again the proper planning and effective communication, which is specified in Regulation 94A. According to the Regulation 94A of the SEBI LODR, the stock exchange, upon receipt of the draft scheme of arrangement and the document under the sub-regulation 1 of the Regulation 59A of the SEBI LODR, the designated stock exchange shall forward the same to the board in such a manner as may be prescribed by the board. So the next step as prescribed in the Regulation 94A2 of the SEBI is for the stock exchange, that is to submit a no objection letter to the board and stating whether there are any objections which is raised by the exchange or not for the mentioned above draft or not. So then the no objection letter on the draft scheme of arrangement is to be given only after ascertaining whether the draft scheme of arrangement complies with the security laws or not. And after that, getting the no objection letter from the stock exchange, if there is any objection raised by the stock exchange, which is bringing in the objection to the notice of NCLT at the time of approval of the scheme of arrangement, the NCLT as prescribed in the Regulation number 94A4 of the SEBI LODR 2015. So post that, we can here we can discuss some questions and answers which is related to the scheme of arrangement, which is
Just 1 minute, Nayan, 1 minute before you go with that question answers, regarding the sale or disposal of undertakings. There are actually two ways out there. One is through a scheme, and another one is even without a scheme also you can go for. See, as we know that an undertaking, you are given the definition, sometimes it may so happen that undertaking might not be having any kind of immovable properties. Mostly when we go through a scheme is where you have immovable properties and the transfer of immovable properties is involved. Sometimes it may so happen that company is having only the movable properties. If all the movable properties are there, then there is no point. You are just like any commodity you are selling or buying, you can do that also. That is called a spin-off, or you may call it as a slump sale, like that. Through an agreement itself, you can do that. So that point of time, what happened is most of the times I can see you don't value the assets. Each and every asset, you don't value it. Say, for example, that company might be having stock in trade, that company might be having debtors, that company might be having creditors. So mostly those are all current assets only. In such case, what will happen is they will do it as a slump sale. That means for the entire the components, they will consider and arrive at one price. This is most of the times to avoid the sale tax. Under the current regime of GST, I am not aware of how it is being dealt with. I am sure that more or less the provisions might be remaining the same. In such case, you don't require a scheme for that particular purpose. As I was mentioning to you, you are purchasing anything from the market. You can purchase this kind of business unit. We call it as or business undertaking. You may call it also like that. But where you have immovable properties, definitely there what will happen is that the what's called mutation of the properties are concerned, the stamp duties of the properties are concerned, all these issues will arise. For that, definitely you have to have a scheme and you have to go through the NCLT route so that you will have an authentication as far as your immovable properties transmission is concerned. Yeah. Bala, you may add anything further to that, or Dipti.
No, as you rightly say, instead of the slump sale, it is the ad hoc price, which is actually good. I also seen it actually. Individually, no things as well. But only thing is, as you rightly touched upon the GST, I am not very much aware of the GST. Because GST, how it is dealt, probably as you rightly say, the necessary provision may be there. Maybe somebody can actually throw light if they have the things. Dipti?
Yeah, no comment as regards GST and slum cell, Bala and Ms. Bala, you and Sudhakar is very well elaborated.
Transaction through the business transfer agreement through NCLT helps post-transaction while transferring the land records. That is what you also said. Suresh has added that comment.
Yeah, Suresh must be having a lot of experience as far as this mergers, demergers and all are concerned. I'm aware of that.
Mr. Suresh, you want to comment on GST?
Suresh, can we hear from you?
It is slump sale and sale tax implications.
Yeah.
I think probably
Yeah, Sanjay is also a good friend. He is also dealing regularly. Yeah, Sanjay, you can unmute and speak.
I think
If you are selling the individual asset, then that GST will attract. But if there is a slump sale, then the GST will not attract. And in case of slump sale, what happens? The consideration goes to the company. So why people go for the scheme? Because if they want to issue the shares to the shareholders of the company, then the scheme of arrangement is beneficial under 230, 232. So some slump sale through scheme can be done whereby the consideration can be distributed among the shareholder instead of going to the company itself.
Yeah. Thanks, Sanjay, for your input.
In fact, one more reason for why you are going for slump sale is sometimes the companies hesitate to buy the companies or to get the company amalgamated because that company might be having some legacy issues, some kind of baggage it is carrying. So that they want the business, but they don't want the company. So in that case, what will happen is whatever the assets and liabilities which are visible, you are buying them as a one unit, business unit. But if you take over the company, then what will happen is you are taking care of not only the present liabilities, but even the future contingent liabilities also. What kind of a liability, legal or otherwise, we don't know. So sometimes the companies hesitate to take over the companies. Instead of that, they prefer to buy the undertaking as such.
No, but this is the tricky one actually. What happens if you see the definition of slum sale as per Income Tax Act, then for the purpose of slum sale, it should be an undertaking. And if we consider the undertaking, if there are any liability attached to that particular undertaking, automatically you have to take those liabilities also along with the assets. So you
I
cannot
agree.
differentiate. It is like section 219 AA of Income Tax Act. The same way you have to define the undertaking. So you have no choice. Even if you are going for the slum sale, that liability will follow automatically.
I agree with you, but the only advantage in case of a slum sale is, in case of slum sale, you are going to take over the visible liabilities, not contingent liabilities, if I am not wrong.
Yeah, true. Yes, yes.
That's what I was mentioning.
Suresh has added a comment actually. Slum sale will not attract any GST except stamp duty.
Correct. I agree. I fully agree with you.
Yeah, Sanjay clarified that individual asset and.
Yeah.
Thank you.
Thank you, Sanjay. Thank you, Suresh.
In fact, Sanjay, I couldn't see your face. In fact, I don't know whether I know you or not. Why can't you switch on your video? In fact,
I don't know. That video is not visible in this. So
He is my
Oh,
MSc
okay.
batchmate.
Oh, okay.
Thanks, Sanjay.
thanks, Dipti.
Yes, Nayan, go ahead.
Suresh, yeah,
Now we are moving to the common questions and answers, which is related to the scheme of arrangement as per the SEBI LODR. So it's basically a brief again. What is a scheme of arrangement? We can say it's an legal and a regulatory mechanism which is used by the companies to reorganize their capital, structure, and operations. So which involves merger, demerger, amalgamation. So what are the key? Why do companies opt for the scheme of arrangement? We can say the companies may choose a scheme of arrangement to achieve the strategic objective, such as a business consolidation, operational efficiency, and or a value of creation for their shareholders. So what is the SEBI's role in overseeing the scheme of arrangement? The SEBI, as the regulatory authority, ensures that the scheme of arrangement comply with the LODR regulations. And SEBI reviews and approves the scheme, and companies must seek its consent before proceeding with the arrangements. And what are the key LODR regulations?
1 minute, Nayan.
Yeah.
See, SEBI's role is not confined to ensure the compliance with the listing regulations, but SEBI has to see that in this scheme, the shareholders should not get deprived of any advantage at the same point of time. I mean, whatever the promoters are getting it or major shareholders are getting it. But whatever the benefits out of the scheme is there, that should be equally distributed to all the shareholders, number one. Number two, at the same point of time, it is also the duty of the SEBI to ensure that the minority community of the shareholders should not get any kind of what's called as stepmotherly treatment or something like that because of this scheme of arrangement. Sometimes it may so happen the scheme of arrangements may be there, which may be not to the advantage of the minority community. That point of time, the SEBI has a key role to play while giving its NOC for that.
Yeah. LODR regulation contains some specific provision related to the schemes of arrangement, which is including the disclosure requirement, approval process, and protection of the minority shareholders' interest. Now, next question is, how does the SEBI ensure the protection of minority shareholding during the scheme of arrangement? SEBI mandates that the scheme must be fair and equitable to all the shareholders. Independent experts are often appointed to provide a fairness opinion, and the scheme must be approved by a majority of minority shareholders. So what are the disclosures?
The point Sudhakar has actually brought in the protection of the minority shareholders.
Yeah, Sanjay has raised the hand. Yeah, Sanjay.
Yes, Sanjay.
Presently, I am running one scheme. So SEBI has harassed me so much that it took 6 months to clear the scheme. The basic intention in my scheme was I was exiting the old promoter through the scheme and classifying the new promoters. So it was a reclassification of new promoter through scheme. So they say, no, as a consultant, you should not advise your client like this, because if you want to reclassify and all, you must follow the proper procedure. But ultimately, as I was within the legal ambit, they had no choice but to clear my scheme ultimately. But one thing they have ensured, as per the new circular of this June 20, 2023, there is a clause 3B, whereby when I'm issuing the shares to the new promoters, okay, at that time I have to take into consideration the fact that the old public shareholder should be more than 25% at all time. So they put that condition specifically into my observation letter, saying that we are sanctioning the scheme, and after the scheme is approved by the NCLT, when I'm going for the listing, I have to prove once again that my present public shareholding of the company is more than 25% after the post sanction of the scheme.
That is obviously, for any listed company, you have to have that post listing 75%, the minimum 25% public shareholding is required,
Sir,
That-
see, the 25% as such was happening, but they wanted to have the post scheme public shareholding of the present shareholders.
Okay. Got it. See, so that is what exactly this thing, to protection of minority shareholders. You should
Exactly,
not be able to bulldoze the people.
That is why I interrupted and I wanted to
And-
just convey.
Yeah.
And Suresh, at the same point of
Sorry.
the Sanjay, at the same point of time, you have also mentioned one more thing, that reclassification of the promoters through the
I
scheme.
was talking the same.
Reclassification of promoters through the scheme is permitted, provided it is not the only issue, but some other issues are also there along with that. But in the scheme, if it is only reclassification of promoters are there, you may have to go through regulation 31, but not regulation 37.
Yes, it should be a composite scheme of amalgamation.
Correct,
Then only they
correct,
allow the
correct.
reclassification.
Yeah, agreed.
Yeah,
Suresh actually stated here.
thanks.
Suresh has actually said here, some states, while transferring the land revenue department, insist to pay the GST and stamp duty both on execution of the fresh issue of the deed for remaining lease period. We have to argue on that.
Yeah, revenue authorities always they put a claim. They knowingly sometimes also give by that anyway, when you go for appeal or whatever it is, they will lose the case, but still what they do is they will put a claim for that thing because they want revenue.
Yeah, practical difficulties actually.
Correct.
And delay in actual implementation.
So you have rightly said, Dipti, that is there.
Yeah.
Because revenue authorities are always after, for collecting the more revenue. That is the thing. Yeah.
Thank you, Mr. Suresh. Yeah.
Next question would be, what are the disclosure requirement under the SEBI LODR for a scheme of arrangement? We can say the companies must provide the detailed information about the scheme, including its objectives, impact of the various stakeholders, financial implications, and any potential conflict of the interest. And this information is disclosed to the stock exchange and the shareholders. Can a shareholder vote against a scheme of arrangement? Yes. The shareholders have the right to vote for or against the scheme of arrangement during the general meeting, and the scheme requires the approval from a specified majority of the shareholders, including a majority of minority shareholders. So how does a SEBI ensure the transparency in this process? SEBI ensures the transparency through the rigorous scrutiny of the scheme documents, ensuring that all the material information is disclosed to the shareholders. So the regulator also reviews the compliances of the scheme with the LODR regulations. So after this question and answers, we can see that compliance monitoring is really necessary, and performing the compliance check, it is really crucial when approving the scheme of arrangements. And compliance ensures that the proposed scheme adheres to the legal and the regulatory requirements, safeguarding the interest of all the shareholders which is involved. So here are some key reasons which is highlighting to the importance of performing the compliance check. We can say the legal and the regulatory adherence. Compliance check ensures that the scheme of arrangement aligns with the relevant laws and the regulations, including those set by regulatory authorities such as SEBI. So then this will help the company to avoid the legal challenges and ensures the approval, the smooth approval process. The second one could be the transparency and the disclosure. Compliance requirements, the mandate transparent, disclosure of all the material information which is related to the scheme. And this transparency helps shareholders, regulatory bodies, and other stakeholders make informed decisions. So this non-compliance may lead to the misinformation or the hidden risk. And then next would be the risk mitigation. The compliance check helps to identify and mitigate the potential risk which is associated with the scheme. And this includes the financial risk, legal risk, and risk which is related to the impact on the stakeholders. Addressing these risks is essential for the successful implementation of the scheme. And the most important is to avoidance of penalties and the sanctions. So the non-compliance with the regulatory requirement can lead to the penalties and the sanctions. And by performing compliance check, companies can avoid this legal consequences and financial penalties that may arise from the violating the regulatory norms.
More than the financial penalty, the time involved and the things spent in sorting out the issue, that is more important actually here.
Yes.
So there's a saying, if it goes as if you think compliance is expensive, try non-compliance.
Non-compliance, right.
So you'll get to know it when you get into that umbrella.
So this is the scheme of arrangement has an impact on market dynamics. We can say the scheme and transaction under the SEBI LODR, they have a significant impact on the market dynamics and the investor sentiments. So we are understanding the market implication is crucial for the informed decision making. And we should always adapt a best practices in navigating through the schemes and transaction, which is essential for ensuring the efficiency, transparency, and stakeholders' value creation. And we should always learn from the industry benchmark is imperative. In conclusion, I can say the understanding the regulatory nonsense and the procedures for the scheme of arrangement and sale of disposable undertaking under the SEBI LODR regulation is essential for unlocking the opportunities and fostering the sustainable corporate growth. Adherence to the regulatory, the compliance, and ethical conduct is paramount for the realizing the stakeholders' value. Thank you. And if you have any questions, you may please ask.
Yeah. In case of the merger of the two listed subsidiaries of the same listed holding company, what will happen to the share of the holding company in the merged company of the share swap transaction if the holding company already holds 70% of the shares in the subsidy? Which shares of the subsidy which remains?
That whenever two subsidiaries merged into the holding company, that point of time, whatever the holding company is holding in the subsidiaries is concerned, that gets cancelled. In the good olden days, we used to have a kind of trust route. So what used to happen was that you created trust and transfer the shares to that trust. That point of time, you were able to preserve the holding of the company in the trust for the benefit of the shareholders. If anyone knows about ICICI and Reliance schemes, they can understand this. But in the present context, that is not permitted. If I'm not wrong, in the Companies Act 2013, post that, it is not permitted. The trust route is not permitted. So you have to necessarily cancel the holding of the holding company, if I'm not wrong. Yeah.
Suresh has actually said, transaction through the prisoner transfer agreement through the NCLT help post-transaction while transferring the land record. Slum sale will not, this he has already put actually. One more thing, I think, let me go back. Does the undertaking include a wholly owned subsidiary?
Not to my knowledge. It may be, may not be. You have to see, you cannot just say an yes or no answer in this kind of webinars. You need to examine that and then only you can say that. It may be, it may not be.
Yes, Sanjay. Sanjay has raised the hand. Yes, Sanjay.
Yes, Sanjay, we would like to hear from you.
Yeah. Subsidiary cannot be an undertaking. Subsidiary just fall as an investment into that holding company. So it cannot be classified as an undertaking.
Thanks, Sanjay. Sanjay,
Sanjay, I agree. I agree with you on the face of it. I also said the same thing, but at the same point of time, sometimes it may so happen we may be able to show it as an undertaking also. That's why I was just mentioning that it all depends upon the facts and figures. Because Nitika has given that the holding company is having that it is a single segment as per the SEBI financial, something like that is there. So we need to see that, we cannot just say yes or no answer in this kind of webinars. But on per se, it looks like it is not an undertaking.
okay, thanks, Sanjay.
Thanks.
Yeah. Any other question or anyone wants to say something, Mr. Suresh or Sanjay, any inputs? Or any participants? Yeah, Mr. Suresh, yeah, please. Can you unmute and just speak, please?
Most important point actually when we are going for any corporate restructuring, one important point is only what is the total transaction cost. And generally we also ensure that once you have a post restructuring, how you have a plan to integrate the businesses. This is when you are acquiring the global business, you are going to have your marketing strategy, your HR portfolio, and all those things should be in such a manner you plan that it should be as early as possible integrated so that you can start leveraging the benefits of your global presence. Second, we generally complete the transaction, getting NOC, getting NCLT order, but the crucial journey starts only post transaction, means when you are going for transferring your assets in the name of the transferee, then there are a lot of hurdles are coming. You require various regulatory approvals, like if you have a leasehold land, then you have a very marathon, I should say, and seeking approvals, going for adjudication. Always there is a challenge. You go for adjudication, authorities say why you are requiring the adjudication. We are certifying, you make the payment, and okay, we will clear your transaction and we will mutate the property in the revenue department. So I think it should be a decision from the management side that once you go for mutation, you should always have an adjudication order. That will protect to the transferee company always.
Absolutely.
Maybe a slightly lengthy process, but it is always good practice. As a good corporate citizen, we must ensure no matter once the transaction is concluded, then there might be some additional cost, but it should be properly recorded, land in the name of the transferee. So this is the one of the crucial. And when you have a multi-state, means different states you have a land situated or manufacturing facilities, then you have to plan in such a manner that the additional cost should not be a burden for the transferee company. How you have to go, wherever there is a capping facility is available, you have to evaluate and plan, propose, and make the payment and get the sort of benefit. These are the some of the learnings which actually we wanted to give to our group. Make sure that there should be no pendency about this kind of land transaction. That's the one experience we learned.
Excellent, Suresh. In fact, people say that experience speaks. It is visible now. The kind of experience what you have working for such a big conglomerate, you have said
Yeah.
that. In fact, that at one point of time, I don't remember, one of my friend was telling that handling a merger is more than labor pains. I said, handling merger, like post-merger activities are more labor pains than of the merger as such. Because working for Reliance, I know that what kind of labor pains I have undergone post-merger of these things, and especially in case of mutations, in case of stamp duty, all these issues. And it's a really, that sometimes it may be a nightmarish thing also. In fact, he brought very finer points. At the same point of time, if the participants have understand what he said in the first beginning itself, before you conceive a scheme of arrangement, most of the times it happens that company secretaries are involved in the legalities only. But what he was trying to say is that you have to have a blueprint of entire thing, not only of the ones that suppose pre and post amalgamation activities. You have to also get involved into that how the business is going to operate post amalgamation, that also is equally important. That is what's called as a comprehensive blueprint of that scheme, Not only the legal part, most of the times whenever the amalgamations and restructuring comes, we confine ourselves only to the legal part, not to the other part, It is equally interesting. And in fact, okay, that Suresh, I request you at one point, at an opportune time, we will organize a program on the corporate restructuring, and you and Sanjay should come as speakers for that, or as a panelist for that.
Yeah, I'm just sharing one experience actually. No, prior to this NSE, BSE, only the seeking NOC, there was a 7 stock exchanges you have to take in addition to regional stock exchange, all the NOCs from the stock exchanges. So every stock exchange they wanted now the subsequent post merger or demerger, you are required to enlist your shares to with our stock exchanges. Once the concept is started that now you need not required to go for other stock exchange if the shares are listed on BSE, NSE. So that's the one big challenge we have also faced. Then ultimately we have told them it is the decision of the shareholder, not the decision of the company or issuer, that where the shares are listed. Since the scheme is already specifically mentioned, then why you are insisting in one of the stock exchange? Then ultimately we have mentioned that okay, we will not go for any listing on this stock exchange. If it is this the case, then we have to go for the delisting. So this is the way. Sometimes there is a lot of pressure, but we have to think from the interest of our investors or shareholders, where they are more comfortable when they have a very national platform, when the shares are in demat, shares are available or T1 basis, then why we should go and have this kind of different approach. So this is the one challenge also. And yes, post acquisition, there are so many activities involved. Just getting order, informing to stock exchange will not suffice. There are requirement informing to the regulators like RBI, your post transaction shareholding pattern and all those things is also required to be informed. Issuance of shares now these days is now not a big problem. Making payment about the stamp duty on the fresh shares, and you can release the shares through corporate action. But this is also a reconciliation is also important by having a practicing company secretary involvement thoroughly. And we may have first checklist what you have a activity for the corporate restructuring, and post transaction you have to see what are the activities are still remaining. Maybe after 1 year you will find that yes, we forgotten and there are certain activities which are still required to be complied from various obligations which are not just only under the Companies Act or the stock LODR SEBI, but RBI regulations. There is a other insurance regulator like. So periodical reporting is also required for certain period from them. Once you have a cross transaction, global transaction, at the time there are a lot of crucial compliances post, not only just getting a permission from here, but there are national security department is also there, like in US and other locations. You have to be very, very careful what contents you are giving or material you are supplying to them. Thereafter, now you have to comply to them. These are the just learnings I just shared with you.
Thanks a
Great,
lot.
Dipti, I don't know whether
Thank
you know
you very much.
Suresh, whether you know Suresh or not. Suresh works for Birla Group at the corporate level, and a very experienced person, having a reservoir of experience at his command. And at the same point of time, he attend all our webinars without fail. And in fact, at one point of time when I met him, he told me that 11 to 1, his office, he has passed a dictum that 11 to 1 on Saturdays, he is not supposed to be disturbed.
Oh, thank
Very
you.
true. It's a very informative, very sharing of knowledge. I must appreciate and I implement whatever the discussion we have in our system. And our group, our company secretaries who are the member of the institute, they are I treat them, they are our next generation who are going to run the businesses and to take India to the global. So this is very important knowledge sharing, and I must appreciate we continue in the same way. This is really admiring myself and remarkable for this Mehta and Mehta.
Thank you.
Thank you so much, Suresh. Thank you.
I think Mr. Pradeep had also raised the hand earlier. Mr. Pradeep, you want to speak? No.
Don't know why they are not able to switch on their videos. We should be able to facilitate, I mean, and okay, give the facility of switching on the videos of the participants also.
Yeah, it is allowed. Once they do that, that even video is allowed.
Because Sanjay mentioned that, he's not able to switch on his
Maybe
video.
at his end.
Anyway, that we will take care of.
So
Okay.
there are two more things out there. In corporate, does the existing team need to take care of the implementing any such a corporate arrangement? How does the team manage resources and the time along with the regular compliances in today's scenario? In generally just understand this. That's what somebody has put. In merger between the two listed company, whether the market value of the shares are only considered for swap ratio.
That's it.
See, in fact, Harita's question that about the implementation of the corporate arrangements post scheme, that's what Suresh has mentioned. You have to have a kind of a checklist that what are the post amalgamation or post restructuring activities, and you have to also at the same point of time identify whose responsibility is what. And at the same point of time, you have to give some timelines also. In fact, in our case, we used to do like that post amalgamation activities, pre amalgamation activities. In fact, in Reliance, for everything, every corporate action, we used to have a checklist. I'm sure that is the case with every company. While merely having a checklist is not sufficient, you also need to have the assignment of responsibilities. At the same point of time, also you have to have a timeline. That is called as the blueprint of the whole scheme. And the second question in merger of between two listed companies, whether the market value of shares are only considered for swap ratio. Swap ratio is to be considered not only about the market valuation, even the future that valuation also you need to say it. So swap ratio working itself is a very complicated and scientific subject. It is not just like, we cannot say this way or that way.
Yeah, I
So,
think.
ma'am, I also had one conclusive statement. So this is again after adding to what Suresh sir and Sudhakar sir said in terms of this is from the business interest point of view, which should be added in the blueprint. So post merger is where the scenes actually start. So what happens is till the merger we have learned professionals are holding your hand, the scheme gets approved. Hardly there is until maybe the creditors vote against or the shareholders vote against. The scheme is going to go. It might take time, but it'll get through. But the post-merger is where the actual challenges start. And if you drill down the records, most of the M&As fail because of the challenges they face in the cultural integration, like the cultural clashes between two companies, because you're two companies coming together with different mindsets, different values, different objectives, different people's style of working coming together. Like the classic case of AOL and Time Warner merger. It's the biggest merger. What do you call it? Disaster which has happened. So one being an old school media company, another being a hotcake internet company trying to merge and create a synergy. Sometimes they say synergy is 1 + 1 is equal to 3, but then when it does not work, if you apply the same formula, 1 - 1 becomes -1. You fall because the valuation of that company came down as the biggest disaster in the US economy. Same again with if you go with the HP and Compaq, prima facie, when you hear these names, you see laptops. So the same line of business. But then when they tried merging together, one was an engineering driven company, another being a sales driven company. It did not really work out. So I think a due diligence should be extended to the extent of what happens after the merger. Is the integration, the cultural integration being in place? What are the precautions to be taken? Because that, like, especially with cross-border mergers, like when an Indian management company is trying to take over, even if you take all the employees in TCS, Infosys, the majority of them are Indians because we are as a resource, human resource available throughout the globe. But then in case you're taking over a company which is, say, in Germany or something, and where you have employees of that country and you're taking over and trying to impose the working culture and the values from the Indian company to that may generate, it tends to be a failure. So I think a due diligence to the extent of bringing in a cultural integration and precautions to fix it would really help save mergers and acquisitions than just getting the scheme approved and get the names on. I think the continuation is where the success lies.
Yeah, I agree with you, sir. In fact, Suhas, what you rightly said, because today's presentation is basically on regulation 37 and
Right, right, sir.
37A, but though we have touched some kind of restructuring activities also, but when we do a full-fledged corporate restructuring webinar, that point of time, we will go more into the practical aspects of all these implementational other related issues are concerned.
Right.
Dipti, before you conclude, let me propose a vote of thanks to Nayan. In fact, I am eagerly wants to do that, because this is one of the excellent presentations I have come across. A lot of content she has put in. She has not confined herself just to regulation 37 and 37A. She has preempted all of us to discuss about the aspects related to corporate restructuring. This is what I always say, that everyone have some kind of initiative they have to take like this, so that what happened is the panelists will also get what's motivated or inspired to speak and give their experience. In fact, thanks, a very good Nayan, excellent presentation you have made. At the same point of time, you have in the intro talk of yours for about 3 minutes, which you have done, you have also acknowledged the importance of the founder partners of Mehta and Mehta. Very rarely people acknowledge that. It is also equally important because they are the people who have taken the initiative of organizing these webinars, and because of which we all are getting benefited, either as a participant or as a panelist or as a speaker. Good, Dipti, and my congratulations to you as well as to Atul Bhai on this. Once again, of course, we always acknowledge your initiatives at the same point of time. Since Nayan has actually touched that what's called as soft nerve, let me also acknowledge that once again. Thanks very much.
Thank you, sir. Thank you so much.
Sudhakar,
Great, Nayan, great.
Yeah.
You have done a wonderful job.
Yes, sir.
Thank you,
So
sir.
Sudhakar says it all.
Yeah, thanks, Nayan. And
I only supplementing him.
actually, I and Atul always believe that, giving and sharing increase or improve your own wealth only and knowledge specifically. And
Atul Bhai, please switch on your video. Always you want to be on the background only. Why can't you come to the forefront? I hope he is there.
He is
Yeah.
there, he is there.
yeah,
I can see him. Invisible he is.
yeah, but he is at some other place, so I think that's why his video is
Okay,
not
okay.
switching out. Actually, I will say that we always like that, and from starting only, we always love to share the knowledge with our own people from the start of our practice. And we want to expand and expand with true intention that our professional colleagues get more knowledge and we get more knowledge. Like today we got it. And this actually we love that even that participant actually share the knowledge. Really, it's success of Mehta Mehta, this webinar. I take it that way. When participants start sharing, then it's a real to professional colleagues and sharing the knowledge. That really give me proud that yes, this is the intention which we achieve.
Definitely, Dipti, you have been doing greatly, the dedicated the knowledge sharing. And many people have personally told me they are looking forward to sort of the seminar every Saturday. They have actually, pre-planned and they have marked Saturday morning, but even this time to this time, they are not available.
Friends, just people are putting the comments about the knowledge. Please read it. Since it's a suggestions and experience sharing, you can read it so that thanks, Mr. Ananda, and also Sanjay, Mr. Suresh, Mr. Pradeep, everyone sharing your knowledge, experience. It's really thankful to all. Thanks, Nayan, for your wonderful presentation, your good work. Thanks, Mr. Suhas. Thanks a lot for your time sharing knowledge. Thanks, Sudhakar, and thanks, Mr. Bala. Thanks all the participants for your knowledge sharing. Thanks a lot.
Sudhakar, you want to tell about the next week's topic?
Yeah. Next week, we are going to discuss about the regulation 38 to regulation 47. That is the last 9-10 regulations of chapter 4. With that, we will be coming to the conclusion of masterclass on listing regulations are concerned. And as far as we are going to, what is the next series of we are going to start? Let us keep it on up to our sleeves. And we are very soon, we are going to announce that also.
Next week, we'll declare that. So when next session? Yeah.
So
Sure.
before leaving this seminar, I would like to add some motivational quote, because after listening to all of you, it's really has given me the motivation, like experience gives a lot of learning. So I would like to quote that I asked for strength, and the world has given me the difficulties to make me strong. I asked for wisdom, and the world has given me the problems to solve. I asked for courage, and the world has given me the danger to overcome. I asked for love, the world has given me the trouble, people to help. I asked for favors, but the world has given me the opportunity. I received nothing I wanted, but I received what I needed. So this is the modified version of a quote which teaches us how it is, upon us to converting the challenges into the opportunities and the achievements.
Just to
Well,
add to that,
thank
Nayan,
you.
that God gives you always not what you desire, but what you deserve.
What we
yeah.
Yeah.
Thanks a lot. Thanks a lot.
Thank you.
Thank
Thank
you.
you.
Thank you very much. Bye.
Thank you to all. Have a good weekend.
Thank you.